Everyone, welcome back to RR Legal Talks. We have two channels, RR Legal Talks and RR Corporates. Now we are discussing on Section 39 of Companies Act 2013, rules for share allotment, daily penalty for non-compliance. If you are planning to public issue of shares or securities, before you allot anything, you must comply with Section 39 of Companies Act 2013. Which lays down the legal process for valid allotment of securities, including minimum subscription, SEBI regulations, and timely ROC filing. In this video, we will explain the minimum subscription, application money rules, SEBI regulations and a minimum percentage. What happens if the minimum is not received? Return of allotment filing process with the ROC. Penalty for delays up to 1 lakh. What is essential for promoters, directors, company secretaries, IPO professionals, and founders? Planning to issue shares to the public under Section 39 of the Companies Act. There are strict rules for how and when a company can allot securities. And if you miss them, you are looking at daily penalties up to 1 lakh. What is Section 39 about? Section 39 governs the allotment of securities by a company, offering them to the public. It ensures that allotment is made only after the minimum subscription amount, as mentioned in the prospectus, is fully subscribed. The application money is paid and received by the company through check or banking instrument only. No minimum subscription, no valid allotments. Minimum application money requirement according to Section 39(2). The amount payable on application must be at least 5% of the nominal amount of the security. SEBI may prescribe a higher percentage through regulations for listed companies or IPOs. So this is as per the section. This prevents allotment based on incomplete or speculative subscriptions. Time limit for receiving subscription. So the minimum subscription is not received within 30 days of the issuing of the prospectus or shorter period as prescribed by the SEBI. Allotment cannot proceed if the money not received must be refunded to. See, allotment cannot proceed, then the money received must be refunded to applicants in a time and manner prescribed. This protects the investors from blocked funds in undersubscribed offers. Filing return of allotment with ROC. Once the company has made a valid allotment, it must file return of allotment, that is PAS3 with ROC. This must be done with the prescribed time, that is within 30 days from the date of allotment. It serves as an official record who received shares and how money received. Penalties for non-compliance: if the company defaults in refunding money after failed subscription, filing the return of allotment on time, then under Section 39(5), both the company and officers in default are liable. The penalty 1,000 rupees per day of default, then higher limits, that is capped at 1 lakh per default. So this is per default penalty, meaning multiple delays means multiple penalties. Compliance checklist for allotment: mention minimum subscription clearly in prospectus. Collect application money only through valid banking channels. Monitor subscription and refund deadlines. File PAS3, return of allotment timely. Track SEBI regulations for any revised application money. Allotment of securities is not just about issuing shares. It is about following the law step by step. Under Section 39, delay or default can cost you penalties, reputational damage, and even regulatory scrutiny. Subscribe for more corporate law and compliance videos covering under Companies Act and SEBI rules and IPO practices. We have two channels, RR Corporates and RR Legal Talks. Please do subscribe for two channels so that you will not miss the latest updates. Thank you.